Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hi, Pam.
We've been doing this show now for over a year, and we're very excited to be doing a live broadcast here at Stanford on Admitted Students Weekend.
Yeah, this is the future lawyers of the country, and the best ones, I might add. I can tell just by your attentive looks in the audience today. Pam, everybody's been waiting for the Mueller investigation to end and figure out what's the result, and it looks like it ended, but I still don't understand what the result is.
Well, one of the things that's different about the Mueller investigation than almost all of the investigations that federal prosecutors do is that we may hear something even about cases that aren't being brought. Because normally the thing about federal prosecutors is they're very closed-lipped, and you don't hear anything if they decide not to charge somebody. But here, people are waiting to find out, well, what do we know, and what do we know about whom?
Well, it's all very confusing to me, and I imagine at least some of the future lawyers in our audience. But today, we have someone that can explain it to us. We have David Sklansky, the Stanley Morrison Professor of Law. He's the co-director of our Criminal Justice Center here. He's a former federal prosecutor. He is an award-winning teacher, a terrific colleague, and someone that's going to tell it like it is.
And also, I've had the privilege of working with David now for 33 years. We were law clerks together, so we shared an office. It's a lesson in, you never get a second chance to make a first impression, and I'll always remember when I first met David, and I'm sure the same will be true of a lot of you. You'll always remember the people you worked with the first time you met them.
And we still speak to each other, even off air.
We do. Amazing.
So, David, welcome to the show.
It's wonderful to be here.
And you've been on before, and you're always good. So bring us up to date to start with. What's going on with the investigation? Where are we, and what do we know?
So we know that the special counsel appointed by the Department of Justice, Robert Mueller, completed his investigation. He submitted a report that apparently runs to over 300 pages. The Attorney General, William Barr, released a 4-page summary of that report. And he has promised Congress that within the next week, he'll release a longer redacted version of the full report. So
when you say he's going to redact the report, what is he going to take out of it?
Well, that's a good question.
Good stuff?
Well, it's a good question what he's going to take out of it. The Department of Justice regulations give the Attorney General the discretion to decide whether any of the reports should be made public. But there's a very long tradition of releasing the report when a special counsel or an independent counsel completes an investigation of this kind. So one thing that the Attorney General is reviewing is whether there's material in the report that should be kept secret because it comes from a grand jury investigation. That would be a potentially legitimate reason to withhold some information. He may also be reviewing it, almost certainly is reviewing it, to make sure that no information is released that would compromise an ongoing criminal investigation or that would release information that would damage our foreign intelligence efforts. There have been reports that he may be reviewing it also to see whether there's anything in it that should be withheld on grounds of executive privilege. That would be an illegitimate reason, in my view, to withhold any of the report.
And David, let's focus on some of these reasons because there's some legal complexity associated with all of them, obviously. On the grand jury investigation, rationale for non-release, it's my understanding that there's an out, so to speak. You could get permission to get things released, and Barr has said he's not going to ask for the permission.
Yeah, there is an out. The rules authorize the Department of Justice to seek a court order to allow release of any grand jury information in connection with a ongoing or potential judicial proceeding. And there's precedent for treating a potential impeachment as a judicial proceeding. So one thing that the Department of Justice could do is seek a court order, and they could ask for the authority to release the report to Congress because it's relevant to a potential impeachment. or because it may be relevant to other potential judicial proceedings. There are also provisions in the regulations that allow the Department of Justice to share information obtained through a grand jury proceeding with officials involved in foreign intelligence and counterintelligence work if it's relevant to that work. And there may be a fair bit of information in this report that is relevant to foreign intelligence.
And that would be relevant to members of Congress on the oversight committees on foreign intelligence?
Yes, because there are separate regulations that require officials in the administration who are doing foreign intelligence work to share information they receive with select members of Congress.
Because this is really about, in part, whether a foreign country interfered with our election and how. And so it would seem like members of Congress want to know, maybe other people do too.
Yeah, it's very clear that many members of Congress do want to know, and many other people also want to know. I want to know. There's a long tradition of releasing reports of this kind. The Starr report during the Clinton administration was released. The Iran-Contra report was released. The Watergate report was submitted to Congress, although it wasn't publicly released. And the reasons for that is that when a special counsel completes an investigation of this kind involving potential misconduct by a president, there usually is great public interest in it and great legislative interest in it.
So one of the things that struck me was, that first of all, that the Attorney General was able to so speed read the report that he was able to produce a 4-page letter off of a 300-something page report in 48 hours. But in that letter, there's a lot going on.
Yeah, because he didn't just summarize the report. He also went beyond the report. So the summary explains that the full report, which runs apparently over 300 pages, goes into two areas of potential criminal misconduct. The first area has to do with Russian interference in the 2016 election, and the second has to do with obstruction of justice. So with regard to the first issue, whether the Russians attempted to sway the 2016 election, the Barr summary says that the Mueller report concludes that there's ample evidence that the Russians did in fact engage in concerted efforts to swing the election in Trump's favor, and they did it in two different ways, through social media misinformation and by releasing stolen emails. With regard to the second...
And there have been indictments on that first
There have been
set.
many
Yeah.
indictments,
Yeah.
some of Russian nationals, some Russian corporations, and some Americans. The Barr summary says that the Mueller report says that there's inadequate evidence to justify criminal charges against President Trump or anybody in his administration for conspiring with the Russians in connection with that interference effort.
Now, is that very carefully worded for a reason, that there's insufficient evidence for a criminal prosecution?
Sure, because when a prosecutor completes an investigation of this kind, the prosecutor usually doesn't conclude that somebody is innocent. The most that they will conclude is that there's not adequate evidence to authorize a criminal investigation. Sometimes they'll conclude that, in fact, the evidence makes clear that there's no criminal activity. In this case, that wasn't the conclusion that Mueller reached.
So they could have thought there was evidence, but not enough to prove anyone guilty beyond a reasonable doubt, and then they would have to say, we're not bringing the prosecution.
Yes, that's right. And then the second area of Mueller's investigation has to do with possible obstruction of justice. And there, according to Barr's summary, the special counsel, Robert Mueller, didn't reach a conclusion about whether there was obstruction because he felt that it was a difficult legal issue and calling for a judgment call. So instead, apparently, the full Mueller report details the facts collected by the investigation that could arguably be the basis for an obstruction of justice allegation. Barr's memo says, although Mueller didn't reach a conclusion about whether any of that legally is obstruction of justice, I will, and I'm telling you it's not obstruction of justice.
So let's kind of pick that apart a little bit. There's an obstruction of justice that's different from a conspiracy. And I guess the notion is you didn't really conspire to do a deed, but you did conspire to obstruct justice after the fact. That'd be Watergate, for example.
Exactly.
And so Nixon didn't conspire to break into the DNC, but he did conspire to stop the investigation. So on this obstruction of justice charge, now we've got two different wings. We've got what Mueller said, which we don't really know because we haven't seen the report, but we actually do know a little bit more about what Barr is thinking on it, because he's given us some indication of his thoughts.
Yeah, actually, he's given us two indications. He explains in this 4-page summary why he thinks that the facts detailed in the report are not obstruction of justice. But even before he was appointed Attorney General, back when he was a partner at a law firm, he sent a letter to the White House and to the Department of Justice explaining why he thought that the facts that he believed Mueller was investigating would not amount to obstruction of justice, even if they were proven. And that letter, the letter that he sent last fall, has one explanation for why the various things that Trump is known to have done or suspected of having doing wouldn't be obstruction of justice. And the 4-page summary gives a different explanation of why it wouldn't be obstruction of justice.
This is Stanford Legal, and today we're talking with David Sklansky about awaiting the Mueller report. So David, can you explain a little bit about, as I read the first letter, what people are referring to as the job application letter, dear Mr. President, make me Attorney General because I don't think you could obstruct justice no matter what you did.
Right.
I mean, his first explanation seemed to be that nothing the president does to shut down an investigation could be obstruction of justice. Is that accurate?
No, he said that nothing the president does to shut down an investigation would be obstruction of justice unless it was something that was wrongful in itself. Regardless, something that wouldn't be lawful no matter what the motivation for it was. Like, I don't know, burning a file of evidence or threatening a witness with retaliation if the witness testified. So Barr's theory in the job application letter was it's not obstruction of justice if the president tells an executive branch official to shut down an investigation.
Because he doesn't want his son-in-law to be indicted.
Right, because there could be legitimate reasons for the president to shut down an investigation. That's a theory that I think seemed implausible to most criminal law authorities, partly because it would mean that President Nixon didn't obstruct justice when he tried to get the FBI to shut down its investigation of the Watergate burglary, since he wasn't one of the since there could be legitimate reasons for a president to want an investigation to close down.
And does the president generally direct investigations?
No, he doesn't. There's nothing. There wouldn't be anything illegal about the president instructing an attorney general to close an investigation for legitimate reasons, but there's a very long tradition of presidents staying out of those decisions precisely because there's a long-standing idea that these decisions should be made by independent prosecutors.
Yeah, I mean, both when you worked for the Department of Justice and when I did, there was a policy in place that essentially said nobody from the White House talked to anybody at the Department of Justice except at the very top level, that line-level prosecutors, or in my case, line-level supervisors didn't take calls from the White House.
Yeah, it's absolutely true, and it was really important. When I was a federal prosecutor, I worked on an investigation where one of the potential targets was related to the president. And it was very important that the White House not interfere in prosecutorial decisions or be seen to interfere in prosecutorial decisions. And in fact, the White House stayed completely away from the investigation.
Now, I want to go, so it seems like, again, I keep saying there's two things here. One is kind of recusal of some sorts, not taking calls. It's not a formal recusal, I know, but a separation, building a kind of a wall between you and a source of conflict. But I want to go back to to Barr's original letter, because the letter seems to say that kind of mens rea doesn't matter.
Right.
That is, if you could have done something had you had pure motives, the fact that you did something with impure motives becomes irrelevant. And kind of a basic fact of, say, criminal law is that a lot of our statutes, really the dividing line is mental states.
Sure, and that's absolutely true with regard to obstruction of justice. That's the way courts have interpreted the obstruction of justice statutes. It's the way that lawyers understand them. I'll say, by the way, on this issue of recusal, there's a very good argument that the Attorney General shouldn't have been involved in the decision about what to do with Mueller's report, given that he got the job by writing a letter explaining that he thought that the president didn't obstruct justice. There are traditions at the Department of Justice that go beyond the legal requirements for recusal. There's a long tradition of attorneys general staying out of decisions where reasonable doubts might be raised about their impartiality, and it seems to me this was one of those.
There's also a longstanding view by the Office of Legal Counsel, who are essentially the constitutional lawyers within the executive branch, that a sitting president can't be indicted in federal court for anything.
Yeah, and it's possible that that's why Mueller didn't opine on whether the facts that his investigation had found constituted obstruction of justice. I mean, we won't know unless and until we see the full report, but one possibility is that he thought that the president wouldn't be criminally charged in any event, at least while he's sitting in office. So this really would be a question for Congress to decide in the context of impeachment proceeding, and therefore it wasn't necessary or appropriate for Mueller to reach a conclusion. That's just speculation, though.
And until the report is seen,
we
really won't know that.
That's right.
So if the report doesn't come out, is there any way for people to get it?
Well, I think the report's going to come out.
Somebody has it on a thumb drive somewhere.
Yeah. Well, I think that the reasons for making it public are too strong, and I'm. I believe in America. I believe things work in the long term, and I think that ultimately we're going to get most, if not all, of the report. I could be wrong about that. A lot of things have happened in the last several years that I wouldn't have predicted.
Yeah, and sometimes when you get things that are redacted, so much of it has been redacted that it's actually hard to figure out.
Yeah, we should talk maybe a little bit about the other theory about why it's not obstruction of justice, the one that Barr put forward in the 4-page summary.
Well, we'll do that in just a moment. We'll be back with more from our guest, David Sklansky, talking about the Mueller report, next on Stanford Legal, here on Sirius XM Insight 121. Welcome back to Stanford Legal. Today we're talking with David Sklansky about the impending Mueller report. And right before the break, you suggested we should also talk about the second rationale that Attorney General Barr gave for concluding there wasn't obstruction of justice.
Yeah, so in the 4-page summary of the Mueller report that the Attorney General released, he didn't repeat the argument that he had put in the job application letter about why he thought what Trump was alleged to have done or known to have done didn't constitute obstruction of justice. Instead, he said, it counts heavily against finding that there was obstruction of justice here, that Mueller's team has concluded that there isn't adequate evidence to allege that Trump himself participated in the underlying crimes of conspiracy with the Russians regarding election interference. So this theory is that if somebody's alleged to have obstructed justice by interfering with an investigation, if they themselves aren't known to have participated in the alleged criminal activity that's being investigated, then that's a strong argument for concluding that they weren't guilty of obstruction of justice. So this theory, I think, is even weaker than the one that Barr put in the letter that he sent to the White House and the Department of Justice last fall. Among other things, it would also mean that President Nixon wasn't guilty of obstruction of justice because he himself didn't break into the Watergate Hotel.
And I've heard that there's a kind of weird third theory, which is if you do it all in public, it can't be obstruction.
Yeah, because in order for there to be obstruction of justice, there has to be corrupt intent. And there have been people who have suggested that since Trump is quite open about what he's done, it can't be obstruction of justice. It's not a plausible theory in my view. It's also a theory that's hard to evaluate even in terms of the factual basis, since we don't know what Mueller found about what Trump had done.
David, are there other, I think we all share kind of perspective here. Is there a consensus of this perspective? And if not, what would be the other side of it, say, within the academy?
Well, I think that I don't know anybody who thinks that it can't be obstruction of justice if you're not alleged to have participated in the underlying crime. I do think that there are people who share the view that obstruction of justice shouldn't be found unless the act that's alleged to have constituted obstruction is wrongful in itself. It's a minority view, but there are other people who believe it. I also think that there are people who are uncomfortable with the whole idea of the obstruction of justice statute because, like a number of other criminal statutes, it's vaguer than you would like it to be. The statute says you're guilty of obstruction of justice if you interfere with an investigation with corrupt intent. And nobody knows exactly what corruptly means.
This is Stanford Legal, and today we're talking with David Sklansky about the Mueller report. And because we're doing a live taping in front of the Admitted Students Weekend here at Stanford, we're going to take questions from our audience. So if you have a question, raise your hand and we'll bring the mic around to you.
Thank you. So very early in the talk, you mentioned potential impeachment as a potential reason for releasing the report. How potential is potential enough? How real does that have to be? What constitutes that actually being a threat?
That's a great question, and nobody knows the answer to it. The thing is that we haven't had that many instances where a court has had to decide whether it's permissible to release a report by a special counsel or an independent counsel, notwithstanding the rules about grand jury secrecy. And not only are there not many judicial decisions, but the statute that governs the investigations by independent counsels and special counsels keeps changing. There was a judicial finding, for example, that grand jury secrecy didn't justify keeping the Iran Contra report secret. But that was based in part on the way that the independent counsel statute was structured at that time. The statute works differently now, and not just because we now call it a special counsel instead of an independent counsel. So there's a perfectly plausible argument that impeachment doesn't count as a judicial proceeding at all. There's also a good argument that it only counts once the House has initiated an official impeachment inquiry. But there's a third plausible argument that if the House is considering opening a formal impeachment inquiry, that counts as well. And we just don't know what a court would say is the answer to that question.
And what David has just done is an indication of what a good lawyer does, which is the answer to almost every interesting question is, it depends.
Yeah.
Most likely legal way for Congress to get Attorney General Barr to release the full report? Would it be that impeachment angle, or is there another way?
I'm not sure. I think Congress is going to get a lot of the report even without that. But I think if they wanted the full report without redactions for grand jury material, then opening an impeachment inquiry would strengthen the argument that there's a judicial proceeding that requires release of the material. I think there's a good argument even without that, though, that they should get the information because of the implications for counterintelligence.
Hi. My question is, I think a lot of us sitting here or at least a little naively thought that there was really a day of reckoning coming for this administration over the past few months. And that's clearly not what has happened here. And my question is, are you at all surprised with the way this has unfolded, given what we knew before Barr's summary came out?
Well, I'm surprised by almost everything that has happened for the last few years. I think that in a democracy, the reckonings happen when there's an election, and we have an election coming up. I'm surprised. I served in the Justice Department the last time William Barr was Attorney General, and I had a fair amount of respect for him. I still do, but I was surprised that he sent this letter to the White House and the Department of Justice last fall. I thought that was inappropriate. I thought it was poorly reasoned. And I'm surprised that he didn't think it was, that he didn't recuse himself from this inquiry once he had got the job in the way that he did. And I was surprised at how quickly he decided to himself opine on whether there was obstruction of justice.
We have time for one last question.
Wonderful. So given that Barr has now opined on the obstruction of justice question, I was wondering how final is that determination? So given statute of limitations not being an issue, could a subsequent attorney general make a different finding? And if not, why not? If so, what could that look like?
There's no legal rule that requires a future attorney general to stand by a determination that a previous attorney general made. There's a long-standing tradition in the Department of Justice of trying to avoid changing interpretations just because a new party has taken power. And my guess is that if there was a new attorney general from either party, that person would put a thumb on the scale in terms of consistency. But no, there's no legal rule that would prevent a future attorney general from changing the Department of Justice's position, nor is there any rule that binds Congress to interpreting obstruction of justice the same way in an impeachment inquiry. Those are decisions that could be made, as we lawyers say, de novo.
One of the things that I hope you've seen a little of today in today's show is there are lots of different ways to be a lawyer, and there are lots of different ways to think about being a lawyer. And you might ask yourself, do you want to grow up to be Robert Mueller? Do you want to grow up to be Bill Barr? One person we've seen recently we know we don't want to grow up to be is Michael Avenatti. So thank you all for being with us today. And Stanford Legal here on Sirius XM Insight 121.